And can I have a thumbs up if we can see the recording button? Sweet. Okay, so hi to all the folks at home. This is IP Law. We are at week 2 and we are looking at copyright. I'm keen to not make this a talk fest by me because you folks, I'm just trying to get sorry, I took my camera off and it's all wangled itself. I'm keen to not make this a talk fest by me because I will need to see that you folks are up to speed with the readings and so forth so that we can grab our group discussion participation marks if you have selected to be assessed by the synchronous video conferencing, which is our Zoom workshops. So if that is you, hey, get ready to rumble. If you are, if you have elected to get graded on your tube participation, don't worry too much about if you want to still post to the Moodle forum. Feel free because the more the merrier there. There has been a few more posts today, which is great. I'll be looking to close off the Moodle discussions on copyright at the end of the week. So get your posts in before the end of the week, if at all possible. Very, very latest, I'd like to see your posts up by Sunday because I realise, you know, a lot of us are full-time workers and so you need to work on the weekends. What I would ideally like to do, and the reason for my email kind of hurrying people up to post to the fora today was to try and, if at all possible, get you kind of up to speed with your weekly readings, because let's face it, you know, the weekly readings for this unit are not burdensome. They're generally less than 50 pages. And so I want you to be able to kind of get over that initial reading each week. Do your post up to the forum if that's the way that you've elected to go, and then start for the rest of the week to try chipping away at the research that you're going to need to get across for your 40% major research paper and your 50% group of assignment, okay, because they're both fairly meaty topics. And as I said in last week's Zoom and, you know, in the week 1 study guide, you'll need to get yourself a decent schedule of work. Plan out the work that you're going to do throughout term and stick to it religiously, okay? So I'm trying to encourage you to get your weekly reading done kind of before the Wednesday shoot, post either by the Wednesday or kind of shortly after, so that then leaves the rest of that week for you to keep chipping away at your assignments. If you are one of the few people that have chosen to write your own research question for that major 40% paper, just bear in mind that you've got now just over 2 weeks to get that to me. So you'll need to be diligently going away and looking at the literature and working out what the problems are there that you can address in your paper. Okay, so that's where we are at with that. Any queries before we get cracking? Hope you all are okay. Hope you're all enjoying the unit thus far, even though we've really only just started. Any queries or questions maybe about last week's Zoom? Anything that's been bothering you? No?
I'll put my hand up and say that I am feeling really a little bit panicky about the research paper because we have to choose now.
Yep.
And you know, we've got to read in advance what topic we're going to pick. And I'm sort of getting a bit worried about, you know, because I don't know anything about those topics yet.
Yes, perfect question, perfect question. So what I would like you to do, is your question mainly about your 40% paper or your group work?
No, it's about the 40% paper.
About the 40% paper. Okay.
I haven't completed my poll. Poll for week 2 on my topic.
Okay. So what you'll need to do with that 40% paper, I would suggest, is do kind of what I'm trying to encourage you to do, which is read ahead as much as you can. But so long as, I'm guessing that many people will, well, the people I've spoken to anyway, are looking to do something around the issue of copyright because it's kind of hot and funky right now. And so if that's you, then by the end of this Zoom, you should be feeling fairly comfortable with the basic nature of copyright. And that should then free you up, so to speak, to then start scouting around in the literature for some ideas, or you can go back to those 2 broad topics that I've posed for you. And as I've said in the week 1 study guide, I'm happy for you to tweak those questions if you want to, or just answer those questions, but in relation to one particular form of copyright, patents, trademarks, whatever. So you can drill down. There is scope to drill down within those 2 broad questions, okay? One's on the nature of reform, one's on the nature of whether or not an IP right or all IP rights have overstepped the bounds of reasonableness, okay? As other people are, as I said to you last week, you'll find that as you do a little bit of poking around in this stuff, that one form of IP right tends to resonate with you more than others. I kind of like them all, but just for that reason, I've been putting up some brain teasers on Facebook and on Moodle just to get you thinking about trademark issues, and I've put another little article up about copyright issues that are quite interesting now in relation to Indigenous copyright. You can have a little look in the week 8 study guide for ideas. You can have a look in the study guide for the week on IP reform. There are loads of links in there for you to look at if that's the 40% assignment you wish to do. But if you want to do something like patent law and you want to use one of those general questions to just kind of drill down into patent law, then obviously you're going to have to wait until week, I think it's 3 or 4, until we do the patent law reading, so that you have an idea of what that IP right is about, and then you can kind of start poking about more carefully in the literature and working out what you think about that IP right. In terms of trademarks, when you're thinking about those, have a look at the week 11 study guide, because there's loads of links in there that should give you some ideas about where the problems are with trademarks. Patent law, there are a couple of different topics. I think it's week, I'm going to say 9 and 10, that are based loosely around patenting issues, and you can look there in those study guides for a few ideas and links about, resources to find and stuff like that. So what you need to be doing is scaffolding your learning in this unit by using the first half to get a decent grounding in all of the different IP rights. And then once you've done the reading for the general nature on the IP right, then, explore around that IP right by looking in the study guides for the back half of term. Does that make a little bit more sense? I'm happy.
It does, thank you.
I'm very happy to hold a drop-in Zoom for us to discuss assessment a little more carefully if you wish to do so. I've already offered the opportunity to do drop-in Zooms if that's what people would like to do on a weekly basis. But if you just would like to do, the odd drop-in Zoom every now and again, do pop into the poll that I've put up on Moodle just to indicate the time that would appeal to you. So I've given you a Tuesday time and a Thursday time for those. Okay? So I want you to feel like, you know, I'm holding your hand through this process, because I know that there are a lot of you that haven't done Scott Beatty's legal research unit yet. So I'm more than happy to kind of, you know, guide you through that process. Any other queries? Questions? No. Okay. Let us jump into things. I can see you're all ready and room to go. I am just going to share my crazy mind with you. Okay, so can we all see what I'm sharing? Okay, no problemo. So you will all have seen, more than likely, hopefully, the tutorial problem that we're going to be using throughout the front half of this term. And I kind of didn't really get a chance to discuss the approach to the tutorials too much last week. But essentially we are doing problem-based learning, and that kind of is a little bit of a scholarly term of art for the kind of iterative learning you get from revisiting the same issue more than one time and coming at it from a number of different angles. When you do that kind of thing, you tend to engage in quite a deep learning exercise, and that's kind of what I'm after with you guys at this more sophisticated end of your degree studies. So, and they, as I said last week, you know, this is the kind of thing that they tend to do in medical schools, for example. You know, they don't just go to the anatomy rooms and, you know, select their actual human cadaver arm that they're going to be exploring for one session. Have a look at the arm, put it back in the bucket and go, well, I guess I know arms now. What they actually will do is come at it a number of different times, and they will dissect it from different and various ways for different and various reasons, and thereby scaffold their learning about that particular part of the anatomy. So that's what we're kind of aiming to do here. Part of the reason for that is because, as I've found when I was in practice, generally speaking, you'll get a client that comes to give you a bit of a brain dump, and they just dump down like a whole massive set of facts for you. Unlike a lot of other units you may have encountered, there are a number of different IP rights that are more than likely bound up in the story that your client's given you. And even within those IP rights, there may be multiple issues of ownership and subsistence that you need to sit down and think about. And so what I've done is I've put them all into this one tutorial problem for us. And then each week we get to tease out more knowledge that we've gained about each particular IP right that is you know, highlighted by the facts in the problem. So that's the way we're going to run it. And I've had students say to me, you know, at the end of term, wow, I saw that one problem and thought, oh my gosh, how's that going to keep us going all term? And now I realise how complicated IP law can be, and just how much can get packed into one fairly simple set of circumstances. So that's what we're going to be doing here. But before we actually get down to answering this problem for the copyright week, and I've highlighted the provisions there that are the parts of the problem that are useful in relation to copyright. What I want to do is some prep questions, okay? And we'll be doing these prep questions each week before we actually jump into the answer, so that everybody's on the same page, okay? And this will give students that have elected to be graded on their synchronous participation the opportunity to really jump in and show their mastery of the subject matter. as well as, you know, providing bits and pieces as we go through the problem. So, and it also helps because then I don't end up talking to myself or just giving a big, you know, talk fest. So let's, without further ado, let's jump into our prep questions and have a think about the categories of original works. What I might just quickly say to you is, does anybody know much about the history of copyright? Has anyone been poking about, doing a little bit of reading about how copyright kind of sprang up and how it all kind of came to be?
Briefly.
Yeah, AJ, all I've got is what you've written in the notes. The copyright arose in the late 15th century as a monopoly granted by the monarch in England over the printing of books.
Printing of books. So interestingly, it arose to protect publishers, not authors, which is a very long way from where we stand at the moment. And I'll touch on that point again when we come back to look at duration, okay? But it arose obviously in Europe. France and Germany are probably the two countries that have contributed most to the global development of copyright. And wow, Germany actually previously had an 80-year term of copyright, which has been wound back. We've obviously had to wind ours up, and I won't tell you how much our duration of copyright is now. But France in particular was a very, very avid protector of authors of the creative arts. And it was France, it was actually a French notion to protect things, all of the associated things that we have now bolted on to copyright, things like moral rights, things like artist resale rights, okay? All of those things tend to stem from the continental European view of copyright, in that it should be as comprehensive as possible to protect authors as much as possible and thereby stimulate human creativity as much as possible. So that's a little nutshell about the kind of the background of copyright. The categories in Australia that we protect of the Part 3 original works, what are they?
The literary, musical, and artistic works.
Yes.
Dramatic as well.
Dramatic as well. That was Jack. And who was that? Was that Jacinta?
That was Kate.
Kate. Good on you, Kate. Exactly. So we have literary, artistic, music, and dramatic works. You're absolutely right.
Computer programs?
Sorry, what was that?
Computer programs.
Ah, beautiful. Exactly. That protection was very, very hard fought and won. The software community was up in arms after some early indications that computer programs were not going to be protected. Can you tell me why they originally were not thought worthy of protection?
Was it because it was a compilation of code?
It's just a bunch of zeros and ones. And sorry for all the computer programmers out there. I normally, every time I run this, I normally get someone that gets horribly offended about that. But yes, they weren't thought to be sufficient to warrant the protection as, for example, a literary work would. Exactly, but they certainly are protected nowadays. What are the categories of Part 4, subject matter other than works?
I got sound recording, published editions, TV, sound, and sound broadcasts.
That's it. Beautiful work. That was Kate again, was it?
You've
So
got two.
nice. Okay, so duration. Oh, can I ask you the categories of Part 3 original works? Where are they housed? Let's put in the section so that everyone's got that under their belt. The categories of Part 3 works.
Is it in section 189, the definitions?
Here. Wait, what's happened here? Where have my... There we go. So you're looking at, what was it?
So 189, the definitions, I thought,
If you just look at...
of what is a work.
If you just look here, there. Oh, sorry. Nature. Original works. That's the nature. Literary music. There we go.
In the textbook, it has section 10 as the meaning.
Section 10.
Yeah.
Oh, no, rights. It's the rights. Sorry. Infringement by doing acts. There we go. Literary, dramatic, musical work, and then artistic work down here. I was right, section 31. So there's your categories: literary, dramatic, musical work, and artistic work. Alrighty. So, section 31. Categories of Part 4 subject matter other than works. We've looked at that. And they are down here, Part 4. There we go. So you can see sound recordings, films, TV broadcasts, sound broadcasts, published editions of works. So what exactly is covered in published editions of works? Because remember, this is a separate copyright to the author's copyright in the literary work itself. And here's where you start to get the layering. What do they get protection for? Let's have a look. They get the right to make a facsimile copy of the edition. That is, they get copyright in the layout, the format, things like fonts, and so forth. Okay? The same way that, all right, somebody go through with me. I put this up on Moodle, so everybody should know this. What's the kind of layering that can occur, for example, around a song that's streamed on Spotify?
That can include the musical work.
Musical work.
As well as the sound recording. And there's the artistic work for, say, the, cover of the album.
Yep.
That's all I got.
Yep. There's also, what else?
The lyrics as well, the lyrics of the song.
Yes. Yep. Lyrics of the song. What about? Melody. Sorry, what was that, Jack?
The melody.
The melody. Yep. I think we had the music mentioned earlier. What about the words? What are they going to get protection as?
Literary work.
Literary work, exactly. And if you notice on Spotify, if you subscribe, sometimes now when you play your playlist, you won't just get the album artwork that pops up, you will get the music video. So what do we have there?
The dramatic works?
Yes, if there is additional dialogue in the music video as well as the lyrics in the song. So, for example, in Michael Jackson's Thriller, there's a set of dialogue that goes along with that music video. So sure, you're going to have copyright in the dramatic work there. And who's going to own copyright in the actual film, the cinematograph film?
That's owned by the maker of the film. So
yes, and who's usually the maker?
Director.
Yeah. So you can see already just one simple item like that can have multiple rights. Okay. So you need to be thinking very carefully when you're teasing out exactly what copyright attaches to any one thing, because you may well find that there's more than one set of rights that go along with it.
If a director or a producer was working for a film company, wouldn't the company own the rights? If they're doing it in their course of business, of employment?
Gemma, nice question. And I think we'll probably put a bookmark on that, because we should be able to answer that in just a second in relation to commissioned works. Duration of copyright for original works. So this is part 3, subject matter.
It's 70 years after the end of the calendar year in which a number of events occur. Either the author for some artistic works dies.
Yeah.
70 years from when, if it's published or under a pseudonym, from when the work was published. 70 years from when the film was published, and 50 years for sound broadcasts.
Yep. So you're looking at the next question as well, Jack. Nice to see you thinking ahead. All right. So generally speaking, for original works, it'll be a 70-year protection period. We have had a little bit of movement, haven't we, in the duration for part 4 subject matter, have we not? What's the story with that? Let's go films, sound recordings, broadcasts, TV and sound, and then published editions. Who'd like to handle that one? Films, what do they get, generally speaking?
Films are 70 years, and so are sound recordings from the first published.
Yes, Kate R. Good job. 70 years.
And the TV and sound broadcasts are 50 years for me.
Aha! We have had a little bit of movement, like I said, and in fact, it's so recent, it applies from the 1st of January 2019. I told you, copyright, in fact, all IP rights it's jumping around all over the place. So movable fees. Anyone know what the current duration is for anything that has cropped up subsequent to 1 January 2019? No?
Has it just gone to 7 years as well?
Yeah, they've evened it out. So TV and sound now 70 years on and from 1 January, up from that 50-year threshold that Kate spoke about. Published editions only 25 years. Look at that. Why do you think that is?
Could it be because they're always getting updated? Like take our textbooks, for example. They're always being updated, or new printing with presses and things?
Quite well. Possibly. And that's a very practical reason. But I'm thinking of a broader policy reason.
Have a stab. Is it perhaps so that because if they gain another 70 years from republication, they could almost get a near infinite protection, copyright protection?
Yeah, I think that's certainly part of it. The other thing is, just because the book industry in Australia has been tying up copyright works here and making them more expensive here for a very long time. And I think the government has been under pressure for many, many, many years to keep that on the down low. So the 25-year term reflects the fact that, copyright, publication copyright is really a secondary overlap of the original copyright that belongs to the author. And you know what, after 25 years, perhaps that publisher needs to free up the market, so to speak. Okay, allow other people to copy their work. Normally what will happen to the author's copyright when they sign up a book deal with a publisher? Have a crack. If you were a publisher, what would you require of your authors?
Well, you need them to give you the right to publish it. So you need to give a license for it.
Yes, absolutely. Most important, as a minimum, they would need a license of the copyright. Some publishers actually require authors to assign over their entire copyright in the work to the publisher.
That's forever? That's once it's been assigned, did they get it forever? Is that right? Or
it depends on the wording of the assignment. I mean, if it's anything less than the entire copyright duration, then it won't be an assignment, it'll be a license. Okay? So, but a lot of scary publishers actually do require authors to sign over their copyright. I actually had this, I had an article published in the famous, very famous journal in the sciences called Nature. And they are so big and so famous, they don't want any copyright problems down the track, and so they just require a complete assignment, or they won't publish you. And normally authors are so desperate to get published in there that they'll just assign everything. Here, have everything. Just publish my work. Okay, so that's duration.
So with that, can I just double check? So I'm the one that works for APRA AMCOS, so we pay the songwriters. And is this the same for like other type of writers, that there's a 50% share that has to go directly to the songwriter, and no matter what their publishing deal is?
You're talking about the royalties that get paid?
Yeah.
There's no real standard set royalty. It really depends on how much negotiating leverage the author of the work, the band, the performer, whoever it is, has, and what kind of deal they can strike up as to how much they'll get.
We actually have, it might just, I don't know if it's, I think it's in one of the statutory licensing, so it's a bit...
statutory licensing, sorry, I missed the beginning of what they pay. So statutory licensing, you're saying that is everything the same? Is the...
Yeah, so we essentially, the writer, even if they assign their rights or have a publishing deal or anything like that, they still retain 50% no matter what their deal is for the other 50%.
Is that in relation to sound recordings?
No, it's to do with the musical works.
Musical works. I would expect that of a decent statutory licensing scheme. I haven't looked at statutory licensing for a long time. That's interesting. Do you have something that you can post up on Moodle for us?
Yeah, I'll find something.
Yeah, that'd be really interesting to have a look at, because, as I said, I haven't looked at statutory licensing for ages. Why don't we protect only original works? Anyone want to have a crack?
It ensures that it's not copied from another work and it comes from the author directly.
Yes, so it minimises copying, unauthorised copying. Anything else?
Well, if you copyright something that's been copied, then the original author won't be able to copyright the original work.
Your original copyright will continue to subsist, but the subsequent work, if it's an adaptation or it builds on the original work, then that will be an infringement. Okay, so the original owner of copyright in the work can sue the subsequent downstream user. Okay, I'm thinking more of a policy issue, and as I say here, it interrelates with the idea-expression dichotomy. So you're not going to get copyright protection unless whatever it is that you've created is sufficiently acceptable to warrant protection. And what I'm talking about when I say it's sufficiently acceptable, I'm saying you can't claim copyright in things that, in words, for example, that are just in common parlance. Because if you start blocking off, fencing off great slabs of the English language, or whatever language, I mean, copyright's a global thing, you're going to be fencing off parts of language, and that is a fairly serious thing to do. So the courts and the policy makers are very careful to place the boundary for copyright protection in a sufficient manner so that we don't start fencing off the language. Okay, so and I'm thinking here particularly of literary works. Normally, things like artistic works, you don't normally have a problem with originality there. Most artistic work is to just inherently be original. But I'm thinking particularly of literary works here. You've got to have some base level where you say, you know what, there's got to be a public domain, what we call a public domain. There has to be sufficient room for subsequent creators to create. Yes? You'll find this idea floats underneath all of the IP rights, but they tackle it differently. Okay? With copyright, it's the notion of originality. Is there a notion of originality in Part 4 works?
No, it's not the same. You just need, because the broadcast is something that essentially comes and goes in a way. I can't remember the exact wording.
Yeah, it's ephemeral is the word you're looking for. Yeah, no, it's not. There is no real originality requirement in the legislation expressly. It's basically just defined by the outputs. Okay, briefly, commissioned works. What section do we look at in relation to commissioned works? Because this is important for our problem question. Anyone know? It was discussed in the text. Okay, I will jump in there for us. So, section 35(2). The author of a literary, dramatic, musical or artistic work is the owner. Okay. That runs counter to what a lot of people think. So if you commission a computer programmer to write some software for you, who owns the copyright?
The programmer?
The programmer. So as contract lawyers, if we had our contract law hat on, we would say, well, hang on a minute. You've had an agreement to make something. There's been offer, acceptance, consideration, all that good stuff. They paid the work for the work, and the work, as in the program, has been delivered to them. Shouldn't they own it? And here you have to be really, really, really careful about the distinction between the copyright in and the rights, the property rights to the product of what's being created. So if they transfer you a file by way of a USB, for example, I don't know, or some device, you will get ownership of that, but they will retain the copyright in it. So you have the intangible right, the copyright that floats along with the product, and you have the hard thing, the product itself, okay? When you have a commissioned work, you'll get the thing, but you won't get the intangible right, okay?
What about if you had the idea that was so creative that you mastered it all in your head, you just didn't have the IT know-how to do it, so you actually created the original work, like mind map, I guess you could say, but you didn't create it?
No, you wouldn't, because you can't copyright an idea.
That's why I highlighted the idea expression dichotomy. You can't copyright an idea, and that's part of protecting the public domain. So you'll see in the text that they talk about Donahue and Allied newspapers. And that involved a person telling their story to a journo, the journo writing up the article, and then there was a dispute about who owned copyright in the article. Allied newspapers claimed copyright of the journo's article, and the person who had told their story also claimed copyright. It was the person's story, it was their idea, but copyright protects the form of expression, the tangible form of expression, not the idea. And this is the big downfall of copyright, okay? If you want to stop other people from making a cake that you've invented, you can't write down a recipe and then expect copyright to stop other people from making the cake, okay? Because it will stop them copying your recipe on a photocopier, but it won't stop them following the idea that's underneath it. If you want that kind of protection, you're going to need to look to something like patent law, okay? So, important distinction there. Having said all of that, and
sorry, AJ.
Yeah.
Can I just jump back a little bit? So you said if you commission somebody to create some a computer program for you, he owns the copyright to that computer program. But what if I'm Microsoft and I've employed all these computer programmers? Surely, because it's part of their employment, surely then Microsoft. Otherwise, Microsoft would be, full of all these people claiming that they've got the copyright for all of Microsoft software.
Yep, and employees where they create works in that have copyright subsisting, it will. I'm just trying to look here. So, generally speaking, there's a case. Actually, I'll put it down here for you.
If you're an engineer or an architect, you don't own that work you do if you're working for a company. You don't own any of the drawings, nothing.
Employment is different to commissioned works. So let's put that up top here. Employment is different to commissioned works. Note, okay? And the case I'm thinking of is Electrolux and Hudson, okay? And there it was a fight about, and then it normally devolves into a fight about what is the scope of your duties? Did the creation result as a result of your normal duties, or did it result from something that you did that fell outside the scope of your normal duties? Okay, but if it's within the scope of your normal duties, it'll just be an employment, a work that's arisen as a result of your employment, and then it will cede to your employer. Okay, but that's not a commissioned work. Okay, cool. Nice questions, people. Very nice questions. Okay, let's jump into the problem. Okay, so very quickly, because I know people have to run at pretty much 7 on the smacker. I'm assuming everyone has read the problem. Can I have a yes? Beautiful. Okay. So the bits that concern us tonight really are the issues around Nigel and Roy's friend Mary, who comes up with this interior menu layout. And, well, you tell me, the other bits that might bother us. I'll flip down. Okay. Other things? Other broader issues? There's the issue in relation to what else?
Are we just answering the questions that you've got up there?
I'm just doing a bit of issue spotting at the moment.
Okay.
So the first set of issues are around the menu. The second are around the manual. And the third are around Fred. Okay? So, let's go. What's the question a court's generally speaking going to ask if there's anything sufficiently original here? When we're looking at the business name Hungry Max, could you use copyright instead of trademark to protect the business name Hungry Max?
I don't think it would, because there needs to be sufficient effort put in and it can't be too trivial. So I think Hungry Max might fall into that.
Yes. Does anyone want to build on that? Flesh that out a little bit?
Well, it needs to be, sorry, it needs to be...
Oliver, then Tanya.
It needs to be either a part 3 works or a part 4 subject other than works, and to come under that part 3, it needs to either be literary, dramatic, musical, or artistic. Obviously, the last 3 don't apply, so the only thing it could come down to is literary. But there's nothing really sufficient in 2 words for it to be a literary work. I mean, it doesn't contain any informative information, and it's not a novel or anything like that. It's just a 2-word name.
Yes, and Tanya, do you want to build on that?
Yep, I was just going to say generally titles are not protected by copyright.
Aha! Exactly.
Yeah, it doesn't sort of meet the basis of literary expression. And
Yes.
Having a look in the textbook, we could follow Victoria and Pacific Technologies and ICE TV Proprietary Limited, which found that TV program titles aren't sufficient to lead to a copyright, because otherwise you'd be copyrighting 2 words out of the English language.
Exactly. Well done. Yes, exactly. So Victoria and Pacific Technologies was one case where the copyright was found not to subsist, and that was in the very imaginative help driver in danger, call police, phone 000. Yeah, no real surprises there, not sufficient to warrant copyright protection. There's one other case I'm thinking of. And the slogans in this case, I just love the slogans. The resort that offers precious little. The resort that offers precious little. And somewhere in the Whitsundays. Anyone remember that one?
Is that Sullivan?
Yeah, that was Sullivan. So, taking those, there was interestingly another case in the UK that involved the Exxon, the word Exxon, the petroleum company, And they came up with a test that it had to afford information, instruction, or pleasure. Now that's being discredited. Okay, so generally speaking, the threshold will be fairly low, but not non-existent. There's no requirement of novelty like in patent law, but you do need to have something that is, as they said in ICE TV, as Oliver said, you have to have something that is reasonably extensive and of significant character to be a literary work. Okay? So the literary work that we would be looking at trying to protect here would be here, Big Macs. So I'm thinking no copyright there. Did anyone come up with a different view? Okay. But Nigel claimed that copyright existed in the manual. Seems to be a compilation. What's the threshold for compilations?
It needs to be, some labour and expense and creative spark or exercise of skill and judgment. Yes.
Yeah. So what was the case that talked about it was sufficient to have just an industrious collection of data?
Is that Telstra?
Desktop marketing systems. And then in ICE TV, they said, no, sorry, we need something else. And it was interesting because ICE TV, you know, they had a good hard look at decisions in America. And those decisions had required a modicum of creativity. And the court in ICE TV ended up saying that you need industrious collection and creativity. So what about their manual? Industrious collection and creativity. A large manual, okay, so it seems to be significant, substantial, including everything that they need and how to make the burgers and so forth. What do you think? There's a lot of data in there and so forth. They've compiled everything that they need all together basically as a business process, and I think probably.
So I had the case in Vivid Entertainment and Digital Cinema. A database and a list containing the names of customers was deemed to be a literary work, and that was just a list. And in the facts stated, it does say that it was recorded in a large manual with all the instructions. And so it's not just a compilation of facts and information, rather a work of toil and creative endeavour. There would have been a lot of taste testing, you know, a lot of labour involved.
Yes, I agree. Absolutely. So I think probably protectable. All right. Can we then say that Fred infringed copyright in their manual?
Not unless he's photocopied it and is using that.
Good job, Gemma. So what are the rights that are inherent and bound up with a copyrightable work?
The right to reproduce in material form or make a copy.
Yep.
Communication.
That's it. Number of other things as well. Sorry, I chopped you off there. I should have waited until I copied and pasted. Okay, so, well, look, I think they got problems there. And this is the big issue with copyright infringement. You're not going to be able to stop people using the ideas if they're not doing any of this stuff in Section 31. Yes? All right, can Mary demand the $25,000 for the logo? Do we think copyright subsists in the logo? What do we have in the logo? What was it? It was a man giving a thumbs up with a cheeky smile and winking, plus the words Big Macs, 11 secret herbs and spices, cool for chewing. Do we think that the logo, the drawing, would be a protectable copyright work?
Would it be protected and as an artistic work, but the words themselves would probably not be?
Yes, good job. Artistic work here. It would be an original work of authorship. There's nothing, we're not told. What are the two things, and Tanya, you should know this, what are the two things that you need to show that that would be inherent in an artistic work? You've got to, in terms of originality. No, we had a chat about this in relation to the Nirvana XI smiley face on Moodle.
Yeah, if something's different, it needs to be substantially. I can't even remember what I've put on there now.
It was very good. You can't copy, basically. You can't copy from other people. And that's about it in terms of artistic works. So where you've got a drawing, have a look on Moodle for those that are watching this at home. Have a look on Moodle. We discussed an interesting case in relation to a smiley face that was created by Kurt Cobain from Nirvana. Copyright will generally subsist in artistic works unless there's some allegation that they've been copied. Who owns it? It'll be, we've talked about authorship.
The person who created it.
And that is?
That is Mary.
Yep. Has there been a reproduction?
Assumedly on the menu.
Yeah, on the menus. Maybe on things like inside. Maybe on napkins and stuff. Maybe
presumably on billboards.
Yeah, billboards. Did they take a substantial part? Well, how much would they have taken?
They would have copied it. I assume she made it for that purpose. So.
Yeah, exactly. So she could sue them for copyright infringement if they don't come to the party and pay her off, is the issue.
How does that work? Like, she may have originally turned around and said, hey, I'm happy to draw you a winky guy face that looks like 10 other ones. And now it's only that they've got money, she's now coming out saying, I want the money. But originally, if she said she's happy to do it, how does that play in it?
Well, indicating, if you think back to your contract law days, there was, in all likelihood, no contract between them. And so copyright will just vest in the author. There's been no change of that situation by way of contract, has there?
Yeah, I just wanted to make sure that the author could trump the I was just doing it, like helping you guys out sort of thing.
Yeah. I actually had a matter where there was a little artist that created a logo for Golden Circle. And, jeepers, it was about nearly 20 years later, eventually, after they'd been using this thing for so long, he eventually put his hand up and said, hang on a minute, I I own the copyright in that logo. You have a look at the Golden Circle copyright, the Golden Circle logo. It's really not much of an artistic work at all. But they ended up coming to a license agreement with this person. And this kind of issue crops up in trademark law as well. We'll revisit that when we do the trademark week. The byline in the slogan, what do we think there? We've discussed that fairly comprehensively.
That's the Whit Sundays one, so I don't think it does.
Yeah. I'll just put here, see discussion above, because we discussed that fairly comprehensively, didn't we? So just to be clear in relation to that logo, it was not a contracted, commissioned work. The copyright, so nothing changes statutory ownership. Yes, copyright does subsist under the statute. She'll own. This is where many people get tripped up. Okay, so it looks as though she's got at least some part of a claim against them. In relation to Fred, obviously Fred's conduct now is annoying them because he's set up shop across the road and he's applying all of the knowledge that he's learnt from them. What should they have actually done in the first place? I'm looking here just for some real, this is not law stuff, this is practical real world stuff that you could advise your client. Next time round, how about you do things this way? If you've got to run off to your other tutorial, I understand. I'm only going to be a minute or two.
Would that one be, with the employment one, if they have in their employment contract that anything they create stays with them, does that clear them for that?
You're right. First thing, require an employment agreement. That's the first thing, isn't it? Because unless you've contractually defined your rights, how on earth are you going to litigate them later? Yes. Next thing, I would say in wherever, and this is normal in franchise employment agreements, require a confidentiality provision in the employment agreement. A confidentiality, a provision, and quite possibly a restraint of trade. Ooh, is that ringing contract law bells? You can draft them up to be successful if you do it properly. So, practical tips. I just want to get you thinking practically because you're getting towards the end of your studies now. What could they do about Fred? What's the best option? Just think naturally, laterally, creatively. Good old cease and desist letter. Make some scary noises for your client, okay? That's about the best you can do in this circumstance. But for the substantive part of their complaint against him, really what he's doing is breaching their confidential, making use, naughty use of their confidential information. So we'll have a look at that later on. In relation to Mary, what should they have done?
Contracted it.
What could they do? Sorry, what was that?
They probably should have contracted the work.
Contracted, absolutely. Absolutely, absolutely. They should have, as with Fred. Best thing to do. Oh, sorry. And by that, I'll just put in a little bit more, in your contract, you would want to make sure that you had a what of copyright.
An assignment?
Aha! Yes. Good old copyright assignment, absolutely. Best things to do. What if you were their lawyer, what would you suggest that Nigel and Roy do? How would you respond to Mary's claim? Two things they could do.
You could try to negotiate a lower payout.
Yes! You could. Why is that? What would be the reason you'd say, oh, I'm not doing 25 grand? You've asked for 25 grand for the logo and the slogan.
Well,
now, we know the slogan's got no copyright.
Because they only have the copyright over the logo, and you could just threaten to change the logo.
Yes, yes. And if you weren't wedded to the logo, just tell your client to develop a new one and make sure that you do it right this time under contract and with a copyright assignment. Yep. That's it. Sorry, I ran over a little. If you have to run, I understand, eh? I will pop this up on Moodle for you, so you don't have to worry about scribbling all that down. Any other queries or questions?
Just the last part of those questions that you had there, I wasn't completely sure about what you meant by the commercial alternatives. Could you, is that relate to the copyright.com things? Is that the companies that are there to collect royalties and stuff for artists?
Here, the commercial alternatives that may assist them are the ones that we've just discussed now, just practical things that you can think about.
Oh, I see. Righto.
That might assist them to move forward. With Fred, really all that they can do is, it's a bit of a lesson learned so far as the copyright thing. The only thing that they've really got against Fred is breach of confidence action, which we'll talk about later on in term. With Mary, you can, again, there's a lesson learnt there. Get your contracts in order. You're running a business now. Okay, you might not have been running it for very long, but you've got to start to think about this stuff moving forward. Okay. And you'd also be saying to them, look, there's two things. If you're wedded to your logo, go back with a counteroffer, a lower counteroffer. If you're not wedded to your logo, practically just get a new one. Yes? These are the things I want you to try and think about, given that not all of your legal practice really revolves around plain and simple law, if you know what I mean. A lot of it is thinking laterally, telling the client the lessons that they can learn and giving them commercial alternatives. Okay? Cool. Any other questions?
Yeah, I'd just like to clarify one thing with when it comes to choreography itself. So the way I understand it, and please redirect me if I'm incorrect, choreography where it's it only becomes a copyrighted act once it's performed, for lack of a better term. So who then owns the copyright for that? Does the person who wrote the choreography but doesn't have the capacity to say the dance skills to perform it, or does the dancer who is executing the choreography?
This is another instance of layering. Okay, so you will have copyright in the choreography itself that was invented. I don't even know if that's the right terminology. Devised, I guess, is a way of saying it. So the dancer that has thought up the progression of dance moves will have copyright in those dance moves when they are written down. Usually you will have choreography that is, when it's a professional exercise, you will usually have it recorded intangible format by way of them scribbling down, you know, oh, this is look great, yep, let's do that, and then, you know, let's do this, and that then will be your form of protection, your tangible form. Other than that, what you can do, and I think one of the brochures online that I saw talks about this, often they're in rehearsals and whatnot, they'll just record it on video. Yep. So that's another reduction to tangible form. Now, where that's done by the person that's making up the dance moves, then again, that's sufficient for their protection as a dramatic work. Other than that, where it's actually performed by someone, an artist, you'll be looking at performers' rights.
Yep.
So that's a separate layer of protection. So the choreographer will have copyright in their progression of dance moves as a dramatic work generally, where it's been reduced. And then the performer, once they actually do it, will usually have performers' rights.
Cool.
Yeah, I guess that kind of falls into the same as songs, right? The songwriter, even if they can't sing or they can't play piano or whatever, they can still own the rights to the musical work, but a performer can record that and they will have the performing rights to this, potentially to the sound recording, but not the actual musical work.
Yes. Yeah, absolutely. And this is where it gets really super complicated, because imagine if you were the roadshow entertainment that brings a lot of artists out here, or what's another big live event management company. There are so many layers of rights that you have to negotiate in this stuff. It's quite a complicated exercise. And, you know, you wonder why our tickets to live shows are so expensive. Copyright is part of the reason. And this is why, you know, where people are talking on Moodle about, you know, very, very strongly, and I find this quite endearing because it happens at every term, but people start off going, oh, copyright, you know, all of this stuff is personal creative work. Surely the copyright rights should subsist indefinitely. And then it's interesting to see how you, or whether your view changes over the course of the term. Because hopefully by week 8, at least, you'll see that a really long term of copyright can have some fairly significant economic effects for the rest of us. The paying public that go to shows, that go to creative works, and also downstream content users. Makes it really tough. Any other queries? You're getting the hang of this stuff very quickly. Yay, that's great. Awesome questions. Awesome level of preparation. Thank you very much. And I'll see you next week if you don't have any other queries. Hi guys, go and have a well-deserved dinner. I'll stop the recording.